Good afternoon, my name is Emanuele Dagnino and I'm a member of the research unit at the University of Modena and Reggio Emilia of the Liveable project. After identifying the need for a new focus on the issue of the relationship between health and work and labor law, and after identifying the case of chronic diseases as representative of the new demands coming from the labor market, the research of the unit of the University of Modena and Reggio Emilia focused on an initial assessment of the current regulatory framework regarding workers with chronic diseases in the Italian context. In this regard, it was possible to verify how, despite some regulatory interventions that have attempted to respond to the need for coexistence between long-term pathological conditions and work activity, significant shortcomings remain in the Italian legal system with respect to the identified necessity of ensuring employability and inclusion in the labor market for workers with chronic diseases. Except for the use of the notion of chronic disease to recognize some more incisive protections during the period of the COVID-19 emergency, the only measure that the Italian legislation has introduced to promote the continuity, the maintaining of employment for workers with chronic diseases is represented by the introduction in 2015 of the right to the transformation of the employment contract from full-time to part-time. This is an extension of a previous provision already introduced in 2003, but with limited scope of application to workers with oncological diseases. The legislative intent was certainly meritorious and suggested a new attention in the legislative and collective bargaining arena for the needs of these workers. About 10 years later, however, these hopes have remained largely frustrated. As for the right to part-time work, it has been exercised to a very limited extent by workers with chronic diseases. This is a failure that has several concomitant causes. Firstly, a very restrictive definition of chronic disease relevant to the recognition of the right. This definition presupposes the progressive worsening of the health conditions of the workers, which is hardly consistent with illnesses that, in many cases, are characterized by alternating periods of improvement and periods of worsening of the well-being of the person affected. Added to this is a fairly bureaucratic procedure, but above all, it's the absence of economic support to cope with the reduction in income resulting from the change from full-time to part-time work that limits the adoption of this measure by workers. All the more so given that if we consider that care and medications required by such illnesses are often particularly costly. With reference then to the expectations of a gradual increase in the level of protection, it must be observed that on the legislative front, not only have there been no further intervention on the subject, but some reforms in favor of caregivers have led to the contradictory situation of recognizing more protection in terms of work flexibility for those who care for persons with chronic illnesses than is recognized for workers with chronic illnesses themselves. In the context of collective bargaining, on the other hand, although greater attention to the condition of workers with chronic diseases has emerged, it has been a matter of fragmentary intervention, often limited to specific illnesses. Above all, in most cases, the measures introduced by social partners have been directed at extending the duration of the traditional protection of work suspension with job preservation, and only in a few cases at introducing specific rights in the area of flexible working arrangements, such as remote work and flexible working hours. In this direction, it can be said that the issue of the coexistence of work and pathological status has remained substantially marginal. In the face of this legal framework, and of the limited attention provided by collective bargaining, it is in the anti-discrimination legislation on disability that workers with chronic diseases have found some answers to their needs. While the notion of illness remains distinct and autonomous from that of disability, the evolution of the EU notion of disability has allowed, in some cases, access to anti-discrimination protections even for workers with a chronic illness. This is provided that it is an illness that entails a limitation which results in particular from physical, mental, or psychological impairment, which in interaction with various barriers hinder the full and effective participation of the person concerned in professional life on an equal basis with other workers, and the limitation is a long-term one. Although the inclusion in the notion of disability can offer some important guarantees, both in the anti-discrimination sphere, including reasonable accommodations, and following the recent reform of 2024, also in the sphere of policies to promote the inclusion of workers with disabilities, it is a perspective that fails to fully respond to the need for continuity of employment for workers with chronic illnesses. Beyond the well-known and persistent fears of disclosure due to the disability stigma, it is necessary to consider that access to these guarantees and measures is conditioned by a significant gravity of the chronically ill worker's condition. As a consequence, illnesses that are worthy of protective intervention remain outside the area of protection and remain so until there is an aggravation such as to fall within the notion of disability. As case law shows, this entails, at least up to now, a more reactive and defensive use of these protections, which workers try to access at a time when dismissal has already occurred or is imminent. On the other hand, as anticipated, the management of the modern health and work nexus would require continuous attention to the development of the workers' health conditions and to the sustainability of the work activity, so as to make it possible to identify any need to support or change the employment trajectories in advance, by proactively intervening on the adaptation of work to the health conditions. Proactive interventions that may occur both in the same workplace and through transition paths to other occupation within the company or in other companies and sectors.